What is up, guys? It's your friend, the Lazy Life Guide. Thank you for joining me again today. I really appreciate your company. Today, let's talk about the law of agency. Now, what is an agent? An agent is a person that represents another person, which is called a principal. So an agent acts on a principal's behalf. There are several advantages of having principals and agent relationships. For example, the agent may have more expertise in a particular field, the agent may have his own network of contacts, or the agent may have comparative advantage compared to the principal. As such, it makes sense to use agents in our everyday lives. However, there are some problems when we try to use an agent. The agent, by virtue of having more knowledge than the principal, may try to use this opportunity to take advantage of the situation and use this relationship to his own advantage. This problem is especially pertinent in areas like corporate law and corporate governance. In fact, the two most pressing agency problems in the field of corporate law is that between shareholders and management and between majority and minority shareholders. So in this case, shareholders would be the principal because the shareholders are the one that owns the company, and management would be the agents because it is managers, employees running the company. So there is a risk that management, which are the agents, may use this opportunity to their advantage and engage in activities that reduce the shareholder value. In the second scenario of majority and minority shareholders, the majority shareholders would be regarded as the agents because they are the ones that are in control of the company. The majority shareholders are the one that executes the decisions most of the time. Whereas the minority shareholders, if they do not have 25% of the vote plus one, they may not be able to veto decisions made by the majority. So there is a risk that the majority shareholders may act in a way that reduces the value of minority shareholders for their own advantage. Now, the whole area of corporate governance, therefore, tries to regulate this area of risk that arises between the principal and agent relationship. So today I want to talk about some of the broad strategies that several jurisdictions and legislations have done to try and mitigate this agency principal problem. There are a total of 5 legal strategies that various jurisdictions have come up with to try and protect principals. The first strategy involves constraining the agent. In other words, the whole thrust of this strategy is to try and limit the agent by prescribing a set of norms that the agent must follow in this agency relationship. And there are 2 ways that the agent can be constrained. This can be done either by rules or by standards. Let me talk about rules first. Rules serve to constrain agents. Rules are different from standards in that rules specifically mentions what the agent should do or what the agent should not do. So this is a really literal form. You can think of it like coding, for example. When you code, you're telling the computer very specifically, I want you to do this in step 1, and then step 2, I want you to do that, and then in step 3, I want you to do this, so on and so forth. This is the same thing with rules. Rules really go through in very great detail what an agent is supposed to do or what an agent is not supposed to do. So these are very detailed descriptions of what the agent is expected of. So these are generally best executed before the agent acts. Since the conduct that is being prescribed by these rules are so detailed, it makes sense that these rules apply before the agent acts. It won't make much sense to give these rules after the agent acts because it is kind of pointless. So that is rules, and that is the first way in which an agent can be constrained. However, the problem with rules can also be said with coding as well, or vice versa, in that when you try to prescribe rules, it is very difficult to describe an activity in such great detail. For example, if I were to ask you to describe the procedure for maybe making a peanut butter and jelly sandwich, for you it seems simple, right? I mean, take 2 pieces of bread, put the peanut butter and jelly, and then put it together, and that's it. But if you really want to drill down into the details of how to make it, then you really have to prescribe along the lines of, well, you need to take out the peanut butter from the cabinet. And to do that, you must first walk to the cabinet. You need to stretch out your hand. You need to grab the handle of the cabinet door. You need to open up the handle of the door really slowly in an outward arc. You need to use your other hand to reach in and take out the peanut butter. Then you must put all your fingers around it, and then you must grasp the peanut butter, and then you must lift it up, and then towards... You get the point. It is easy to prescribe conduct, but it's very difficult to prescribe conduct in very, very great detail. So it leaves a lot of room for loopholes in the process. If a jurisdiction, for example, prescribes that majority shareholders are to act in the interests of minority shareholders, what does act in the interests mean? Does this mean action, or can I say omission as well? So I don't act in the interests of shareholders. Can that also be penalized? That is a problem. When you try to dictate everything in such great specificity, you will inevitably leave something out. Or you may come across a situation that the rules itself did not even contemplate. And therefore, there is a need for standards. Standards are the second way in which agent can be constrained. So the first one that constrains agents are rules, and now the second one will be standards. Standards are different from rules in that standards are not a specific kind of instruction, but rather they are a more flexible kind of impetus, if you would. So instead of maybe saying, with regards to the peanut butter and jelly example, instead of saying everything that I just said, walk to the cabinet, stretch out your hand, grab the handle door, maybe a more simple way of describing it would be, make a satisfactory peanut butter and jelly sandwich using the peanut butter in the shelf and the jelly in the refrigerator. For example, something like that. So in this case, there are some general terms there like satisfactory, in the shelf, in the fridge. So those are more open to interpretation, and they kind of serve as a form of general description of conduct rather than a very, very specific specification of conduct. And since these are so general in a sense, they usually apply after the agent acts. In other words, they can be used by courts and by judges to assess an agent's conduct after the agent has acted. So it's kind of like looking backwards in the rear mirror and seeing what has already happened and using these standards to interpret the agent's conduct and give judgment based on that general and broad standard. So indeed, some might argue that, well, since the agent has already acted, any damage that is being done or any harm that's being done to the principal has already occurred. And that is true. Indeed, in my opinion, I think it's better for rules to step in before the agent acts, but standards can also be important to deal with future instances. So for example, if an agent has acted in a way that is unsavory or unsatisfactory in a particular way, and the courts interpret it via a standard to say that this is not satisfactory, then it will apply to all future cases as well. So this is how the law acts in that sense. It protects principles before the agent acts through rules and after the agent acts through standards. So that is the first way in which principles can be protected by the law, through rules and standards that constrain the agent. In the next video, I'll talk about another legal strategy that can be used to protect principles, and that is the terms of affiliation.